Welcome to Common Sense Mediation Academy, Drafting Summaries and Memoranda of Understanding. We are really excited to have you joining us in this pre-recorded fashion, and we're looking forward to being able to review and discuss your various assignments and activities that will follow after this. So let's take a quick look at what this program covers and how it's set up. So there are a number of things that we're going to talk about throughout this program, and we've divided them up into 4 different segments. As you go through the segments, there will be opportunities for you to stop and either reflect or participate in an activity, and then just hit resume on the play button, and away you go to watch the rest of the video segment. After you've completed all of the segments, or even in between segments, depending on how you want to engage in your follow-up assignments and activities, you'll attend to some practicing, both in a video format for yourself as well as a written format, and you'll just make arrangements with the office by emailing admin@commonsensemediation.ca in order to make all of the arrangements that you need to set up the timing that will work for your schedule. And we will also be providing you with a follow-up workbook so that can supplement some of your activities that we're going to be talking about in the recordings. Do please keep in mind that in order to receive a certificate confirming that you have participated in this program and are eligible for the 7 hours as required under the regulations to meet the definition of a family mediator for the purposes of the minister's list, then you will have to complete the various different activities and assignments and submit them to us. Once we have received everything and have had an opportunity to give you some feedback, if you've been successful in completing those activities and assignments, then we will provide you with a certificate of completion. We also provide a letter that confirms various different programs that you take through the Academy. And so if you've taken other workshops or intensives, or you're going to be taking more in the future, just know that whenever you're ready to submit your application to the minister, or if you are using this for some other purpose, like for example, to demonstrate annual continuing education credits that you may be required to take under your own different professional organization, or to maintain your designation with the ADR Institute of Canada, we can provide a letter for that confirms those hours, as well as if you're applying for one of your designations. So through ADRIC, you may be applying for a qualified mediator designation, also referred to as a QMed, or for your chartered mediator designation, which we refer to as a CMed. So we're going to work through all of the various different materials, and in total, there'll be enough hours between what you watch on video as well as the assignments that you attend to on your own that you'll easily have covered off the 7 hours. In fact, you'll likely have invested more than 7 hours in learning and practicing and digesting this information. And as I know that you're all familiar with hearing us talk about this at the Academy, but we are huge promoters and believers of lifelong learning, and that you can't get enough of this. So you might want to even watch these videos and try these exercises more than once. And anytime you run into any difficulties, you have questions, or you want to be able to just check to make sure you're on the right track, we're only ever email or phone call away. So let's get into our materials. We are going to be breaking this into the following components. It's in the beginning, what are some of the documents, the written documents that you're going to be wanting to and needing to put your mind to at the very beginning of a mediation? What are some of those written documents that you will be drafting and providing to your clients and sometimes to other professionals throughout the mediation process? And at the end of the mediation process, as you are transitioning your clients either to work work with another professional, such as their lawyer, or they are exiting the mediation process, either because they've gone as far as they can or because they have reached a resolution, and you're going to be assisting them in documenting that in some way. So sort of the written components that are at the end of the mediation. Now, we also know that often folks will come in and they will mediate with you for even just one meeting, and then they're off to do something else, but they may come back again in a matter of weeks, months, or even years. Sometimes folks will mediate through a series of meetings, and then they'll reach their agreement that at that time feels like it's a full and final agreement. But then as life carries on, there may be new circumstances, especially for people who have children, and over the years something new comes up and they return to mediation. So whenever we talk about sort of the end, we know that that's not really a defined period or a defined date in time. It's more through the cycle of each time that you might be working with a couple or a family. So we're going to talk about what are some of the documents that you need in the beginning, and that's this main subject of this particular video out of this series. We want to talk about what those documents are, how they come into being, and why they are important. So in the beginning, what do you need? There are two primary documents, the retainer and the agreement to mediate. And if you think about the distinction between the two of them, the one is really about your business relationship with your clients. And that is a separate document, so that if there was a question for anybody, yourself included, around what was agreed to with respect to what kinds of services you're providing, how often you're providing those services, what the cost of those services would be, and what the limitations are to those services, you have a document that reflects those terms. Whereas the agreement to mediate document is one that is where the parties are agreeing as to what process that they're going to be using, and you're actually a party to that agreement, because as the mediator, you are also agreeing to that process and what those parameters are. Now, you will see in some instances and some people's practice that they'll combine both of those documents together so that it's a retainer and the agreement to mediate. And there's nothing wrong with that. We do suggest that it's helpful to have two separate documents. And one of the primary reasons for that is that you may have even more than two parties, but you'll have at least two parties unless it's just one person needing to mediate with themselves, and that would be highly unusual. So it's more likely than not that you're going to have multiple people that you're really entering into a contract with for the provision of services. And so depending on the billing model that's set up, it may be that each individual in the mediation will be responsible for paying a portion of your fees. And if you have one party who hasn't followed through on that obligation, and the other party or parties have, then the one party that hasn't followed through on their obligation, you would have a standalone document that then you would be able to utilize that if you needed to do something more formal to try to collect on those fees. Now, having said all of that, best business practice would be to try to set up your fee and billing arrangements so that you would minimize the risk of accounts receivable and having to, for lack of a better way of putting it, hunt down somebody to pay your bill. And those are some of the finer details that we talk about in our business building workshops. So for today's purposes, we will look at these two different documents as standalone documents, knowing that if you would like to merge them, you may, but there are also good reasons for keeping them separate. So how to use these documents? There's some fundamental questions. You know, when do you present them to your clients? When do your clients actually sign the documents? And what happens if you have a client who refuses to sign one or both of them? And you could think of many different scenarios, of course, in which somebody might be reluctant to sign paperwork. And just like we do in mediation, it's important to try to understand what is underneath the surface of that reluctance. Why would somebody say, you know, I'm not really comfortable in signing that document, and try to understand what the issue is, what their concerns are, what their assumptions are about what would happen if they signed that document, and do some brainstorming to be able to see if there are other options that still ultimately result in them signing the documents. But sometimes it's about the timing. Sometimes there needs to be some additional conversation about what it is that the document represents, and perhaps with the other party or parties that are involved. So let's start at the beginning. When do you present these documents to your clients? Well, it kind of depends. And if you've worked with us before, you know that's one of our kind of standard answers to all questions, because it's true. You want to be developing your processes in such a way that you can have consistency and you know what happens next. But within those processes, it's super important to have flexibility that can take into account the unexpected and the unusual. So in most instances, you would likely be presenting the retainer agreement upon your first contact with your client. And so that first contact would typically be in an intake meeting. Now, you may have your client look at the retainer in advance of that first meeting, and it may be that they actually even review the retainer, execute it, and send it back to you before you've even met them. Now, I just want to pause for a moment and tell you that I'm going to talk about these two documents one at a time, because though you could provide both documents together, there are some good reasons, just the same way as there's some good reasons to keep those as separate documents, there's some good reasons to think about your timing of those documents separately. So if you're going to be meeting with your clients through a video or virtual type of format, then before you have that first meeting, even that intake meeting where you're introducing yourself and coming to understand the client and what their needs are and really their story for the purposes of the issue or issues that are going to be mediated, then to provide them with that document in advance to be able to, and by the document, I'm of course referring to the retainer, for them to be able to review, ask you questions about that, and hopefully sign the agreement before you've invested time in that intake process with them. I think you will find that to be very helpful from a business development perspective. If you're going to be meeting with them in person, you could certainly send the retainer agreement to them in advance so that they could take a look at it and highlight any questions, bring that back in, rather bring it with them to that first meeting, or you could provide it to them at the first meeting, that intake meeting, and you could sit with them to say, here's my standard retainer agreement. I'm going to leave you for a few minutes so that you can read through it. Here are some of the highlights, and then allow that to be sort of your introduction to each other, establishing what your business relationship is going to look like. Now, I can anticipate some of you have some questions, even at this early stage in our program, and that may be, well, what will be in the retainer? How long will the retainer be? What if the client is consulting with you either for free, or they're unsure if they want to use mediation? Won't the retainer agreement come across as a little too aggressive if you're doing it right at the beginning? So with respect to the contents of the retainer agreement and how long it is, we're going to talk a little bit more about that and even give you a chance to try drafting your own for some feedback. But one thing that I would say even right now is be thinking about that retainer to see if you can keep it short, sweet, and simple. If you can keep it to only one page and covering off the main points, perhaps even in a bullet form, that the main points that you really want to drive home with respect to what the arrangement is between you as to either your hourly rate, or if you're using a different type of billing model like a flat rate, fee for service, a subscription. There are all sorts of different ways in which you might set up your billing arrangement, and also what your availability is going to be like, things like whether or not there's a conflict of what would happen in the event of a conflict, and that it's for any information that you gather during the course of the conversations, whether those are individual or joint or in between meetings, that those maintain there without prejudice and confidential nature, so that they couldn't be utilized for other formal future processes. And some of that will also actually be in the agreement to mediate. So there are some things that sort of live in both documents and some things that are more specific to a particular document. And as you work through these documents, we're going to ask that you just be very reflective on that as to what you see as the fundamental purpose of each of those documents in your own individual practice. We're going to give you that opportunity to play around with these documents to come up with your own, something that just resonates well with you, rather than just simply giving you a sample document and saying, here, why don't you model something off of this sample, because everybody's practice is going to look a little bit different. So coming back to the question of when to present the retainer. So as I said, you may present that to them in advance before you've even met with them, or right at the beginning of when you're meeting with them for that first individual consult. If you decide that you're going to do either consultations or individual meetings for free before the parties begin their joint sessions, then perhaps the retainer is something that you talk to them about during the course of that consultation or that meeting. You leave it with them to be able to review and consider signing at a later time. Excuse me. However, if you are going to even charge a nominal fee for a consultation, you may find that it would be helpful to include in your retainer what your fee is for that initial consultation. Now, excuse me for a moment while I just take a quick drink. And whenever I have to pause, you can take that as a time for you to pause as well. Okay, so in the agreement to mediate, though you might give that to your parties in advance as well to be able to review and to note any questions that they have, there is something really quite powerful about having the parties sit down with you to go through the agreement together and then both sign at the same time. Keeping in mind that the agreement to mediate is the document that governs the process as between the parties and yourself. And is not the business document that governs your business relationship with each client separately. So that, let's say, sort of ritual of sitting together and going through each section that talks about things like the confidentiality, about full disclosure and willingness, coming to the table with good faith, and even thinking about things like how they're going to exchange information and perhaps communicate with each other within the process of these things that they're agreeing to when they sign the agreement to mediate, are also sort of starting to establish some of the ground rules of the mediation process. And so providing that document to them in advance to be able to read through and really process and then come together before it's signed, that can be a very helpful way to really kick off that very first meeting. Now, if you have a client who refuses to sign one or both of these documents, as I said before, you really have to kind of try to understand, well, where does that resistance come from? And often it comes actually as a result of the fees. So you may have a client who is concerned about sharing fees. They may feel that it's important that the other client is the one who is solely responsible for fees, or they may be wishing to share fees on a proportionate excuse me, a proportionate to income basis. And those are all things that are very possible. You may decide to have your retainer agreement worded in such a way that like leaves a blank, so that you can discuss with each of the clients individually how they envision sharing those fees and be able to plug that in. Word of caution there, though, is that that's actually going to be your first negotiation with the parties, right? So if you're wanting to have them execute the retainer in advance of starting the actual formal and joint mediation, to have a negotiation within that document will probably delay the finalizing of that document, because you'll want to discuss that in the first joint meeting, unless this is something that the parties have already talked about and they give you instructions. It may be best to have a default that says in your retainer agreement that all the parties are what we call jointly and severally responsible for your fees. And so what that means is that joint nature of it is that they both have equal responsibility to those fees, but severally means that if one person wasn't to pay, then you could ask the other person to be responsible for the full amount of the fees. And if that's your default wording, that kind of covers off the, how it's going to be shared between them for the discussion in the joint meeting, with really the, I guess the default in the absence of deciding to do something differently would be sharing the fees equally. And if one person wasn't paying, then you would know that you'd have the ability to seek the full payment from the other party. So that's one reason why somebody might refuse to sign. Another reason is that we see come up from time to time is someone who's skeptical that the other party is actually going to participate in mediation, whether they're concerned they're going to show up or if they're going to show up in good faith. And it's a little like, well, I don't want to sign until you've signed, and so who's going to go first? And so if you can try to just normalize that whole piece of saying they're just standard forms, we get everybody to fill them in, they become part of my file, you can each have a copy, and whether you choose to give them the original copies or you just do that by scanning if you're going to be paperless, those are some of the logistical things for you to put your mind to. And as you work through these different exercises, if you have ideas about what you'd like to try on the paper management in addition to the drafting, let us know and we'd be happy to talk to you about that. So our first exercise here or activity that we'd like you to engage in is a bit of a reflection. So you've heard me talking about both of these documents a little bit, and anything with respect to the retainer, anything that you might have heard me speak to, and anything that you think maybe in addition to what you've heard me speak to that should be or could be involved in or included in a retainer. This is part of your reflection. So take 5-10 minutes and just brainstorm with a piece of paper, or if you're more of a typing person, list everything that comes to your mind that you think should be part of a retainer. If you already have a retainer document that you have either been using or you're thinking of using, then take that time to review the retainer and note if there are any words that you think could be changed to keep it simple and clear. I don't know exactly what the research says. I want to say it's at a grade 5 reading level, but I don't know if that's the actual official age or grade level. But the point is, it's less than on what we typically will use in our correspondence as far as an understandability, a common understandability amongst people, to say, like, keep your words simple, and we don't have to try to buff up the words to make it sound like it's more important than what it is, because it's important already, even with simple words. And you have a much better chance of compliance with those documents if people understand what it is that the documents say, and you have much less risk of somebody afterwards saying that they didn't understand what the document meant. So take a look at what you have, if you already have something that you've been using or you plan on using, and just sort of note for yourself anything that's kind of a bit of a bigger word or a longer sentence, and ask yourself the question, is there a way that I can simplify this? With the goal of keeping it simple, keeping it clear, keeping it understandable. And what are the key components of your retainer? So when you're looking at your document and your retainer agreement, whether it's been reduced to one page or you have multiple pages, see if you can just star the sections that you think are the most important. And I'll give you an example of one such section. It's probably super important that the name of your client is on the document. It's also probably super important that your name is on the documents, because that establishes who the contract is between. So that would be something, no matter how much you try to simplify the document, you wouldn't want to get rid of that information. So then think of the next level of information. What else is really crucial to that retainer agreement, when you keep in mind the purpose of that agreement, the purpose of it being to establish the business relationship between you and the individual client. Remember, just because a document is long doesn't mean that it's good. So don't think that you have to have lots of words, long sentences, make it seem confusing. You actually don't need to have fine print. And so I know that joke, or well, I don't know if it's a joke, but everybody's always like, oh, that was hidden in the fine print. That's not particularly helpful, in my opinion, for mediation practice. So we suggest that you hit the pause button here now in this video and give yourself some time to go through this reflection exercise for at least 10 minutes. If you're looking through a document that you've been using, you might need a longer time frame, and then come back and press play, and we will pick it up with the next slide. Now, assuming that you pressed play and you have now returned, here's what your activity is going to be further to that reflection. I want you to actually try to create a retainer. If you already have a retainer that you have been using or you're planning on using, you can continue to work off of that, but temporarily just set it aside. Follow this link here where there is a series of questions and some fill in the blanks that you can follow along to try to create a retainer agreement. So you work through this template, adding the paragraphs that you'd want to include and changing the language so that it's specific to mediation. Now, heads up, this particular link and the document that you could create with it isn't necessarily the document. So it is just a starting point to be able to think maybe a little bit outside of the box as to what you might have preconceived notions on what a retainer could look like, and play around with it. Once you've either got that template sort of in a place where you think it sort of fits for what your purposes are, and if you already had a different retainer agreement you were planning on using or have been using, you can take both, the one that you create through this link as well as the one you had before, and ask a friend to review and provide feedback. So the primary questions that you want your friend to address is there anything in this document that you do not understand? Are there words in this document that you've never seen before that you're not sure what they mean? Is there anything that when you read this document, you're left sort of scratching your head saying, well, I guess I could sign this, but I'm not really sure what it is that I'm signing? Could your friend tell you back just in regular everyday language what they understood this agreement to mean, and if so, is what they say what you wanted it to mean? And we would suggest repeating this exercise 3 times. So revise the document after you get some feedback from friend number 1, and then give the document to friend number 2. Do the same thing, take their feedback, revise further, and give the document to friend number 3. Now, if you happen to be somebody who doesn't have 3 people in your life that you could provide the documents to get some feedback, then let us know, because we'd be happy to plug you in with some folks with the mediation practice group. And you aren't restricted to it just being friends. It could be family. Often family also is friends. So that would be great, kind of combine those relationship statuses. And the point, it isn't so much who it is as much as getting 3 different sets of eyes on your document to be able to get some feedback as to the understandability, the simplicity of it, and if that person that was giving you the feedback would feel comfortable signing the agreement, understanding what the business relationship was between you. Now you'll do that activity after this module, and well, I guess this isn't actually a module as much as just a segment of this program, and you could engage in that activity before you watch the next segment in the separate video, or you could just collect your activities to do all at once at the end of having watched all of the video segments. So that covers the piece about your retainer agreement. Now the second agreement that we want to talk to you about is the actual agreements to mediate. So you'll recall that the first document that we were talking about, the retainer agreement, that's the business relationship between you and your client. The agreement to mediate is the document that governs the mediation process for the parties. So you're included in that because you're the guardian of the process, right? And so you need to be able to understand what your role is, what they can expect from you, and also to have established in that document what you're expecting of them and what are their roles. So how are those 2 documents different? Well, as you've heard me say probably 3 times now, one is about the process, the other is about the business relationship. Do you need both? We suggest that that's best business practice because they have different functions. You could provide those documents at different times in order to reinforce where you are at in the process, and especially that agreement to mediate has a function that you could embrace sort of in the ritual of getting the mediation started as a way of confirming commitment in the room together and adherence to the ground rules. So do you need both? Maybe you don't. Would it be a good idea to have both? We think it is. So you could try both ways and then provide us with some feedback as to what has worked best for you. Now, the question on this slide at the end here is, what do you think is important to include in an agreement to mediate that would not be in a retainer? So when you think about those key pieces that are in a retainer, so the name of the party that you are contracting with, that they're contracting with you to say, well, I will pay you money to provide this service, or whatever the arrangement might be. Secondly, in that retainer agreement is going to be the terms as to the payment and when it gets paid and how it gets paid. For example, you might say, well, I only take e-transfers, so you'd want to make that clear. Or if it's a situation where you collect people's credit card information and you bill them on an agreed time frame, then you need to make sure that it's very crystal clear in your retainer agreement what the details are as far as when you're going to be charging that credit card. You'll want to make some sort of commitment as to protecting the privacy of that information, the credit card information, and confirming that it would only be used for these purposes, and explaining how you're protecting that information and destroying it after you haven't used it, or after you no longer need to use it. And so those business details, what needs to be included in a retainer that doesn't have to show up again in the agreement to mediate. Perhaps those details around the payment. You might, though, still have in your agreement to mediate how the parties ultimately decide to share those fees. In the ADRIC model, the PIECES model, which of course you'll recall, PIECES stands for, the P is for prepare. So this, what we're talking about here, is really that prepare phase, even before you are in that first joint meeting. It kind of shows up in a couple of places, right? You're preparing the documents, some instances sharing some of those documents in advance of the meeting. But then in the prepare phase of the first joint meeting, where you are going through all the various different housekeeping items, the agreement to mediate is one of those items in your list of things that you want to talk to parties about in the very first meeting. And so you're in this prepare phase, and then after everything is all set up and you're ready to go, it's about asking the parties what it is that they want to talk about. What is the issue that they have? So the I in PIECES is for identify issues, where you're developing your agenda. Now, I've seen in some agreement to mediate that there's a kind of a blank spot in that agreement for you to be able to outline what it is that the parties would like to be mediating. What are they there for? If you do insurance mediations, for example, you might get a retainer agreement actually from the insurance provider that says, we're asking you to mediate this particular decision letter on this particular topic. And so it's very defined and would go directly into your agreement to mediate that that is the solitary issue that's being talked about. And of course, each party will have sub issues, and that'll still come up in your process when you're designing an agenda in that moment for that particular meeting. But you can see where it might be helpful, or in fact necessary, to also include in the agreement to mediate what at least the primary issue or issues are. In the high conflict court ordered mediation in Saskatchewan, at the case conference with the parties, where the judge also participates in order to introduce the mediator to the parties and to basically kind of, read them the riot act, to say, hey, you have this opportunity to work with a mediator, don't squander that opportunity, and you are here not because you've been demonstrating that you have the ability to work things out on your own. In fact, you've been flagged as being high conflict and that you need some assistance, and the kind of assistance that the court can't help you with. In that case conference meeting, the agreement to mediate is the kind that I've described, that has the blank spot to fill in what are the issues. And it's kind of like one of the first preliminary meetings, even though you're not in the joint session yet and you haven't done your individual intakes. It's really saying, okay, what are some of the issues that have caused you to end up in court and to be flagged as high conflict, that we can put in this document as a way of recognizing that these are the fundamental issues that you need to be working through. And if people aren't entirely sure what their issues are, pretty much 99.9999% of the time, it's that they need to work on communication. So if all else failed, you could put in there, shall we talk about communication? Would that be one of the issues? Of course, typically when we're working with parties in a family law context, we have issues related to children, if there are children, and issues related to property, if there is property. And then there's issues related to financial support, which is always the case if there are children, and sometimes the case if there isn't children, because there may be spousal support as one of the issues that need to be talked about. And so you could put in your agreement to mediate some of those issues. You wouldn't get incredibly detailed about all of the sub-issues, because in the joint meetings themselves, that's when you would ask the parties to tell you the things that they are wanting to discuss, perhaps in that one particular meeting, to be specific and to build an agenda for that particular meeting. So once those issues have been identified, of course, we're exploring with the parties as to what it is that's important to them in reaching a resolution. What are their priorities? What are their expectations? What assumptions do they have about how, if they do X, that Y will happen, or that Y has happened because X happened? And so, taking time to explore the story behind the conflict, to also identify the concerns and the hopes and goals the parties have for working through this conflict. Now, to be able to really have a good discussion in that explore phase, we know that it's helpful to have ground rules. And the ADRIC PIECES model, the 6-phase understanding model represented in the acronym PIECES, there's another acronym, acronyms within acronyms, kind of like those Russian nesting dolls, right? You take off the first part of it, and then there's another doll, and you just keep taking those off. So within the PIECES acronym, there is the PROUD acronym. So PROUD, which stands for the ground rules of the following: that we agree we're going to be patient, that we are going to be respectful, that we will be open with our information, that we will seek to understand. So not only are we going to be open, but we are going to listen for understanding. So the U is to understand. And that there's about disclosure. So the things that we need to share, we'll be willing to share those with honesty and transparency. So that PROUD acronym, whether you actually spell it out in that fashion in your agreement to mediate, or if you just talk more generally about those characteristics of being patient and respectful and open and understanding, and being willing to disclose and share transparently. You could have each of those as a separate paragraph, and this document helps to introduce those basic ground rules, in addition to potentially identifying what the issues are that the parties are wanting to discuss. So you can see those are a couple of paragraphs or sections in your agreement to mediate that really wouldn't make a lot of sense to have in your retainer agreement, when you remember the distinction that the retainer agreement is about the business relationship between you and the parties individually and collectively, but the agreement to mediate is really all about process. What are we agreeing to do, and what does that process look like? This is also an important place to clarify in writing what your role is, or maybe more importantly, what your role isn't. And so remember, keep in mind, a lot of times people don't really know what mediation is. I always make the joke that until Amazon stops auto-correcting mediation to meditation, we still have some work ahead of us to help the average person on the street understand what mediation is about. So sometimes people will end up in mediation and they will think that the mediator is a decision maker, somebody who's going to tell them what they should be doing. So in your agreement to mediate, you can clarify what the role of a mediator is and what it is not. So you're there as the guardian of the process, you're facilitating their conversation, you're there to meet with them together and separately. It's a good spot as well to be able to identify the parameters of confidentiality. If you're meeting with parties separately, we of course suggest that as best practice rather in mediation is that you do have opportunities to meet with your clients individually. It's a good place to be able to participate in initial and ongoing screening for intimate partner violence issues. Well, it gives a format for the parties to be able to express privately with you any frustrations maybe they're experiencing either with the process or with the other party or parties, things that maybe they're not comfortable talking about in the joint session. But the question is, are those individual meetings private and confidential, so just between you and the client, or is that information that's going to be shared? So in your agreement to mediate, you could identify what the limits of that confidentiality are, and whether you ascribe to the opinion that everything should be transparent between the parties and yourself as the mediator, or if you're going to be providing for there to be confidentiality in those individual meetings. There are good reasons for taking either approach, and so you want to be reflective for yourself as a practitioner as to what way you're most comfortable with, and then reduce that to writing in your agreement to mediate. So you're putting in the agreement that your job as the guardian of the process is to be able to facilitate those conversations. The limits of confidentiality is between you and the parties individually and together, and also outside of the mediation room, that you would only be telling anybody about what's going on in mediation if both parties had provided their consent for you to do so, and that the limits to that, as far as if there was some sort of evidence that led you to suspect or believe that a child was in need of protection, then you would have a moral and legal obligation to report that. So you might as well include that in your agreement to mediate, so that it's clear to folks that that is a limit. The same way as if there was evidence to lead you to believe that somebody's was at harm, it was going to be harmed in some way by one of the parties or both of the parties. I suppose that's possible. Probably not likely, because if they worked that well together to scheme something like that, they wouldn't likely be in mediation. But so it'd be more likely if somebody is making a threat to somebody else, either that's in the room or outside of the room, or they're threatening to harm themselves in some way. And those are instances where confidentiality would be breached in order to protect the people who are at risk. And though that might seem like that's just kind of common sense, and would you really need to include that in your agreement, I think it's really important that you put it in that agreement so that people are aware of what limits there are to confidentiality, and perhaps also just as a way to flag for them that if there is something that is concerning, that it is appropriate to identify that. And that might be something that they identify privately with you, but might also, I suppose, come up in conversation in a joint session. The other time where you might breach that confidentiality would be if both parties said that you could share the information. Perhaps it would be in the transition to lawyers, or it might be for some other purpose, like if they authorized you to contact somebody to do an appraisal for property valuation, for example. Lots of different times when that might come up. Now, there's one little distinction, and that is that if the parties have reached an agreement, and it's an agreement that becomes formalized in some way, that after the fact, if there's a disagreement as to what it was they agreed to, then what was talked about in mediation, the courts have said, could be compellable evidence if the parties ended up boomeranging into court after the fact to say, hey, I know we reached this agreement, but I thought it meant something. The other person says, well, I thought it meant this other thing. And then a mediator could be called in to speak to what occurred in the mediation to help a judge determine what was actually agreed to. So you might want to then make sure you have a clause in your agreement to mediate that says, all things that happen in mediation, including my involvement, are all, it's without prejudice. You can't subpoena me. You cannot have access to my file for the purposes of some sort of formal proceeding, whether that's arbitration or in the court. And so these are some of the key features in the agreement to mediate document. And you'll come up with some other ones that you recognize as important as well. So how do you create this agreement to mediate? Well, you want to be thinking to yourself, what is mediation all about? Like, how does it work? And how might you lay that out in the agreement to help provide a bit of a snapshot for the parties to help them prepare for what the mediation process is going to look like? So I earlier spoke to you about the acronym PROUD and how you could put in your agreement to mediate those guidelines to help them in their interactions. You could continue and actually lay out the whole process if you wanted to say, hey, there are these different steps that we go through. And we will always be preparing for, in between meetings. So prepare phase goes on an ongoing basis. We've already talked about how they need to identify the issues that are at the heart of the mediation, and there may be something that can actually be identified in the agreement, but then through the course of the meetings, those subtopics come up, and that's what you work through. The explore phase, you could use your agreement to mediate to just kind of give them a bit of a snapshot of what the PEACH acronym is about, that you're going to want them to put their mind to their priorities, to their expectations, to question for themselves what some assumptions that maybe they have made or they think the other party has made. What are some of their concerns about the situation and the ultimate outcome? What are some of their hopes about what that can look like? And we know the answers to all of those questions give us insight into the interests underlying of their positions, and those interests that are they come as a result of people's closely held beliefs, values, fears, and needs. And so if you thought that you could do even just a couple of sentences or a short paragraph that just reminds people of this interest-based kind of language, in addition to the questions, those open-ended questions that you would have them put their mind to in preparation for each meeting, you can see how this agreement to mediate could not only be just a document to have them say, yes, we're here to engage in the mediation process, but could be an educational document to help them prepare for that process and for them to continually go back to when maybe they get a little off track. So you say, oh, well, let's not forget what it is that we're trying to do here. When they work through the explore phase and you've developed a goal statement with them, then that is when they're going to create options. And you could write in your agreement to mediate the pacing of that, right? Say, hey, you're going to come in with some positions, some ideas of what the outcome of this should be, but first of all, we're really going to seek to try to understand. And we use our guidelines, our ground rules as represented in the acronym PROUD in order to help us have that conversation, so that then you can come back to thinking about, well, how could we resolve the situation? It might still be your position that you came in with, but it may also have been after you've listened and you've been open to, and you've been sharing, and everybody's disclosing what's relevant and being transparent, that you actually come up with additional options that you'd never even thought of before, and that creates stage before you then are going to evaluate all of those different options to see how well they satisfy the goal statement. And the S in pieces, the ADRIC model has S as satisfying. Here in Saskatchewan, we have decided, the AGIC model is, S stands for solve, but here in Saskatchewan, we have renamed the S in the pieces model to be satisfy. So have you evaluated your different options to be able to determine what you can have peace of mind in implementing. So are you satisfied with that? So you're generating all those options, you're then evaluating them to decide which of those options, or maybe even a combination of them, that the parties that they have decided is what they're going to try to implement in order to satisfy or resolve their issue that they came in with in order to be able to move forward. So how much of that process would you outline in your agreement to mediate? You can think about that. Remember that not everybody like their use of language, perhaps there can be the literacy could be an issue. English may not be a first language. Some people are more visual than others. So does it have to be all written up in the way that we think of a typical contract or agreement? Or could you be creative in terms of drawing out some of these ideas that you're asking them to agree to implement and participate in that mediation process? Then some of those details, like who would be involved in the mediation, well, on the face of it, it's you, and if there's two parties, it's the two of them. But maybe you are conducting mediations that include children. Perhaps it's going to be a multidisciplinary team approach to mediation, where there's a financial neutral and maybe a divorce and separation coach, a mental health professional, perhaps somebody that's providing spiritual support, like an elder or a pastor, or somebody in the mental health realm, such as a counselor. So there could be other people that are going to be part of that process. And if they are, it's super important that they have signed off on the agreement to mediate as well, to be able to confirm that they understand and will adhere to those fundamental cores of confidentiality and without prejudice. The termination clause in agreement to mediate is important. So how do you, if you don't want to keep mediating, how do you get out of it? And how about for you as the mediator? What if you recognize that the parties are stuck and you've tried different things and they just really need to maybe hit the pause button? Perhaps they'll come back to mediation at a later date, but you're just seeing that they're spinning their wheels. It's time to pause. So, or terminate completely. So having something in your agreement to mediate that would speak to who can terminate, how can they terminate, what's required in order to give notice of the termination, and then what happens after the termination of mediation. And I would suggest to find a way to word it so that it always leaves open the opportunity for people to come back. Sometimes they don't know what their alternatives are. So they've maybe been put into mediation because the court has ordered them there, or because it's part of the mandatory early dispute resolution processes, that it's in that jurisdiction. So sorry, you have to participate in some type of early dispute resolution process. And so they come to mediation with no intention whatsoever of actually really utilizing mediation to the full extent that could be a benefit to them, but it's just because they don't know what they don't know. So to be able to give them a graceful exit and the ability to come back to resume mediation, or actually start it if they didn't engage in the beginning in good faith, to be able to do that while maintaining, you know, their respect and dignity and not feeling embarrassed by coming back to you. So thinking about what the language could be in a termination clause that would provide for that. And then what else do you think needs to be included based on what some of your philosophical beliefs and approaches are to mediation, and knowing that this is a document that really defines the process for the parties, and you're just visualize being in a room, virtually or otherwise, with your clients and going through these clauses and seeing them nod their head and say, yes, I agree. Yes, I will participate in this way. Yes, until they get to the point where at the bottom of the document is where they're going to sign to confirm, yes, this is my agreement. How often does an agreement to mediate need to be used after the fact? Well, you might refer to it sort of throughout the mediation process, process that people need to be reminded of roles and responsibilities and ground rules and how the process works. But it's very unlikely that you're really going to, the parties will be needing to rely on this agreement to mediate after they've left mediation. So whether or not they received, they got to a point of an agreement on their issues, or they had to terminate or pause mediation before they got to that point, it would be unlikely that that agreement would be used as evidence of some sort. If anything, it's going to be used more as a defense. So if somebody was to try to submit evidence around what was spoken to or discussed or considered in mediation, that then anybody who was objecting to that would be able to rely on this agreement to say, no, this was a mediation, not just because I've labeled it that way, but because you can see in this agreement to mediate that we agreed to the terms specifically around confidentiality and that it would be a without prejudice procedure. So we are going to do this second activity. So see how busy you are right off the bat. So you've had an opportunity already to just do some reflection, and you have one activity to do around creating your retainer agreement. And now this is your second activity, which is drafting an agreement to mediate. So if you follow this link, this is a very short little article that gives you some ideas around what it could look like and where you might fill in some blanks. But we'd like you to work through that template and add the paragraphs that you want to include, change the wording as you may wish to make it a little bit more user-friendly. And I can see that in this slide, I have some typos here that suggests that you maybe work through the template twice to do that. And maybe that wouldn't be such a bad idea. The first time, do it on your own. Second time, do it as a group, and then reconsider it and try it again. That wasn't really my intent in this slide. My intent was that you would work through the template, and then you would do the same thing that you did with the retainer agreement, where you ask for some feedback and input from at least 3 different people as to whether or not it's understandable. Where do they have questions that maybe you need to have a little more commentary, or that you flag for yourself that you say, well, I won't put the commentary in this document, but I will flag it in my process, that when we're all sitting down together working through this agreement, that I will spend a little bit more time on these clauses, and it continue to refine and rework it to get to a document that you feel sort of represents what you would like to work with, and then you'll submit that to us for our review and feedback back to you. So why are these documents so important? Well, in contract law, if you and I entered into an oral agreement that I said, I would like to buy your car, and you said, great, you can buy my car. That could be considered an contract between us, even though that wasn't written down anywhere. Where that contract would be a little shaky, though, would be there was no clarity as to the terms. Maybe you have more than one car, so how do we know which car I've said that I want to purchase from you? There has been no discussion as to how much I would pay you for that car, or when it would happen, or how that transaction would take place. So though in contract law, an oral agreement is binding, an oral agreement often can not have all of the details to be able to make it very enforceable. So if I showed up at your house tomorrow and said, hey, I'm here to get that car you agreed to sell to me, you could look at me and say, well, I really just don't know what it was that we agreed to. And if I tried to push the envelope and ask a third-party decision maker to force you to sell me that car, how could they do that, right? Because what car and for how much? So you can see with that very simplistic example why it's really important to have things written down so that there can be clarity as to the terms and conditions of the agreement that you're entering into. And that's why I'm suggesting that you try to aim for simple, clear language so that it's very understandable as between both you and your clients. And to have it written down to demonstrate that you have what we call a meeting of the minds. So if I had said I wanted to purchase your car, and you thought car was another way of saying motorcycle, when I went to go and pick up the car and you gave me the motorcycle, then I would say, well, hold on, that wasn't what we agreed to. It would be evidence of us not having the same idea of what was going to happen, and therefore no meeting of the minds. So if you have a written document that's just very simple and very clear, that can support the meeting of the minds. Other things that are part of contract law, I mean, you can't, if you sign an agreement or verbally agree to something and you're under the influence, or you don't have your mental capacity for some other reason, well, that's not going to be a valid or enforceable agreement. So I guess the takeaway there is just to make sure that everybody in the mediation room has come sober and with their full understanding of being able to consider what is in the agreement. If you've provided the retainer agreement separate and apart, there's no way to really test to see what their capacity is at the time that they are executing that agreement. But I think it's fair to say you can make the assumption that they're sober and have capacity when they're considering these agreements. However, be cognizant of some things that might not present themselves as obviously as if somebody's trying to sign something when they're half asleep, is that there are people who are illiterate or really are challenged in terms of understanding the English language or the written word, and they have found a way to be able to pretend that they know what they're looking at and that they're understanding it. So, as much as we can sort of have some assumptions about people being able to understand these documents, be cognizant and aware of the fact that sometimes people have found coping mechanisms. And so check in, test by using your words, by using other visual cues, and just doing lots of things just to make sure that these foundational documents are understood amongst everybody that's part of your process. You also need to make sure that people are doing things of their own volition. So another way in which a contract could be found to be invalid in contract law would be if there was evidence of undue influence or if the agreement was unconscionable. So I think that if people are participating in mediation, it'd be hard to argue that an agreement to mediate or retainer agreement was unconscionable, and unless you as the mediator were engaging in some sort of business practices that were outside of the realm of what we would be supporting and teaching you in that. So we could have a side conversation about that if you're unsure. However, the part about people being there of their own free will, this is debatable. We have historically, mediation theory would say that mediation is really only truly mediation if people are voluntarily participating. But we now have the beginnings of some mandatory provisions within Saskatchewan and in other jurisdictions that may be part of their court rules or their legislation that says you have to participate in mediation before you can do something else. Or in Saskatchewan, we have a court-ordered high conflict mediation program where sometimes the court will say you have to participate in mediation for so many sessions because you need to try something a little bit different. So of course, the people that are coming to mediation under those circumstances, you can't say they're there of their own free will, but they're there because it is part of the process of trying to untangle and sort out whatever it is that they're needing to sort out. And they may not be happy about it, but that's a little bit different than what we mean in contract law. If I was to try to say to you, hey, look, if you don't agree to selling me your car, then I'm going to do something that you really don't want me to do. And so if I'm kind of, it's a veiled threat or an explicit threat about something, then that wouldn't be a contract that would be upheld. Under the ADRIC Code of Conduct, so if you are a member of the ADR Institute of Canada, at Section 10, you actually have a requirement to put the agreement to mediate document in place. And I'll just read that for you. It's on your PowerPoint and on the screen, so you can read along with me. The mediator and the parties shall prepare and execute a mediation agreement. Now I'll pause there just to point out that the word shall means that that's not discretionary. That is kind of a, you have to do this. So the mediator and the parties shall prepare and execute a mediation agreement. I actually find it interesting. It says that, you know, the mediator and the parties shall prepare. So there's the ability to kind of collaborate with your parties on your agreement to mediate. And don't forget about that as kind of a creative option. So you could have your basic document that covers off all of the main things that you want to have in that agreement to mediate. But as mentioned before, you could have perhaps a section that says, well, we're going to fill in the blank here about what the issues are that we're going to be discussing in mediation. Maybe you have a spot to expand upon the ground rules. So you can see there's some opportunity to engage in some collaboration and interest-based discussions even before the mediation proper has started. So the mediator and the parties shall prepare and execute a mediation agreement that sets out the following three components: the terms and conditions under which the parties are engaging the mediator. And so on that point, if you have your separate retainer agreement, which is what we recommend, you might in your agreement to mediate make reference to that, to say as far as the business relationship, the parties acknowledge that they have each separately signed a retainer agreement that sets out what the price is, the frequency of meetings, whatever the details may be that you've included in your retainer agreement. Secondly, the national mediation rules of the Institute apply to the mediation. Any of the rules that the parties agree shall not apply to the mediation. So if you are a member of ADRIC, you want to look at the national mediation rules. You want to make sure that you as the mediator are prepared to adhere to those rules. And it probably doesn't hurt to include those rules as an appendix excuse me, to your agreement to mediate, so that it's easy for the parties to make reference to those rules and know what those rules are. But there is the provision that allows them to choose which rules would not apply to the mediation. So you can put your mind to that, think about what it is that somebody might decide they don't want to have apply, and think about the reasons why they might take that position. And then finally, any additional rules that the parties agree shall apply to the mediation. So when you're thinking about what do you want your agreement to mediate to look like, here are three specific things that you want to be considering if you are an ADRIC member. And if you're not, these are still good things to consider, even though you might frame it with different language. And then other ethical considerations, you know, having your documents in place as part of your best business practice so that it's the same every time, and not necessarily the same content every time, but it's the same process that you're engaging in each time, to say, hey, I have a business agreement with you. We together create this agreement to mediate that establishes our container, our process, our mediation process, what we're aiming to do and how we'll go about doing it. And there are little places all along the way in which you're able to just sort of confirm that everybody's on the same page about what it is that's happening, to see if there are any power imbalances. And just because there's a power imbalance or perhaps evidence of some type of intimate partner violence, a short form of that, IPV, anything that maybe is an indicator of some coercive control that's happening. These are things that don't necessarily screen people out, that you go, oh, sorry, I see that this is happening and I don't think we can mediate. But it's about helping you put your mind to the process in order to maximize its ability to be successful while ensuring, to the best of your ability, safety for the parties. If you have somebody who is asking you to mediate and wants to engage a retainer with you that is a close personal friend or a family member, you want to be thinking about that as a conflict of interest and whether or not you really could sit in that chair, a mediator's chair, as an impartial facilitator to the discussion. You also want to make sure that it's very clear to the parties, and I know we've spoken about this earlier in this recording, but about the limits to which you can protect their confidentiality, as well as the limits beyond mediation around what it is that they talk about and how you would not act as a witness against either of them in any formal proceeding, because you work for both of them. And so these are things that come up as ethical dilemmas from time to time. If you're part of our PODS program, which is our professional ongoing development system, that's a 12-month program where you have an opportunity to engage in small groups with other mediation practitioners to be able to talk about things that come up from time to time, practice by not only doing things like role plays and skill development, but also some written practice and other ways in which you might get some feedback from people. You could also be discussing some ethical dilemmas that come up from time to time, because that's one of the assignments in that program. So ethical considerations and dilemmas and quandaries that come up are always great for some conversation. Be thinking about how you can try to mitigate your risk of falling offside in some way by those initial documents and how you word them and what you actually put in place. And so in our next video, we're going to be picking it up on this part, interviewing clients to collect the information. And so for this segment, we will pause and let you go and continue with some reflections. If you want to just jump right into the next video segment, you can. If you want to take a little bit of time before you go to the next video segment and start to work on some activities, you can do that as well. As you know, this is entirely at your own speed, and you can contact us by email or phone if you're having any difficulty or you have any questions. So I look forward to when you join us at our next segment.